Hello, I'm Bill Kirshner. In this video, I will be discussing the parties' rights and obligations once a valid request for representation under Section 7114A2B of the Federal Service Labor Management Relations Statute is made. This is the 7th of 7 videos on investigatory examinations. To learn more, you can always visit the FLRA online at flra.gov. As you recall under the statute, there are 5 elements to the union's right to represent employees during investigatory examinations. An agency representative must examine a bargaining unit employee in connection with an investigation for which the employee has a reasonable fear of discipline, and the employee must request representation. Although the employee must request representation, the right in Section 7114A2B is the exclusive representative's right to be given an opportunity to attend the meeting with the employee. The employee's request triggers a union's right to attend the meeting, to represent the employee and the bargaining unit. Each of these 5 elements must be present. If any of the elements are missing, a charge alleging an unfair labor practice will not be supported and the charge may be dismissed. Now let's take a look at what occurs when all 5 elements are present. What are the parties' obligations and rights? After an employee makes a valid request for representation, an agency has 3 options. It may grant the request, it may discontinue the interview, or it may offer the employee the choice between continuing the interview without representation or having no interview at all. If the agency gave an employee the option of continuing an interview without representation or having no interview, and the employee elected to continue without representation, the employee waived the right to representation. However, issues often arise when an employer asserts the employee withdrew a request and waived the right, but the employee asserts they did not voluntarily withdraw the request for representation. These issues could be subject to investigation if an unfair labor practice charge is filed, and possibly require a judge to make a credibility determination. Of course, the need for a hearing can be avoided if representation is provided. Where an employee requests union representation, but then agrees to proceed before a union representative arrives, the authority has found that employees can validly waive the right to representation. If the employee waives the right to representation, the waiver must be clear and unmistakable. Whether an employee waived the right to representation is determined by objective factors, and the waiver is not valid if it is coerced. Moreover, an employee's waiver of union representation in one interview does not apply to later interviews. The authority has also found no violation of the statute where the agency postponed an interview to allow the employee to obtain representation, but then proceeded with the interview after the employee returned without a representative.
You are here as an observer only. If you speak, I'll order you to leave.
Is this a violation? Yes. The union representative at an investigatory examination has the right to take an active role. This includes the ability to speak with the employee to make sure the employee is understanding the questions, and the representative is allowed to ask questions to elicit exculpatory information. This also includes the right to speak or participate on the record. The union representative's role can also include seeking clarification of questions and suggesting other avenues of inquiry. Moreover, the authority found that a union representative engaged in lawful conduct, where they made statements on the record, pointed to an employee's previous written statements, or whispered in the employee's ear to ensure a response was complete. An agency violates the statute by improperly disciplining a union representative for attempting to legitimately assist an employee during an examination. An agency, however, may limit the union representative's participation if they are interfering in its ability to question the employee. On this point, the authority has favorably cited the principle that an employer has the right to question and obtain answers directly from the employee. That is, the union may not answer questions for the employee. The authority also emphasized that the mere presence of a union representative at an examination does not interfere with management's right to insist that the employee be responsive or with its right to decide the scope of the examination. It is also important to note that the union representative's participation may be limited if they are verbally abusive or interfere with the interview by interrupting the employee's answers. What about this scenario?
I was just called to report here to represent the employee. I'd like to speak with her outside briefly.
Does the agency have to allow this? The authority has held that while the statute does not grant a per se right to engage in private conferences outside the presence of an investigator, an agency should allow such conferences where necessary to allow the union to effectively represent the employee, and where allowing that does not interfere with the examination's integrity. Conversely, where the union representative and the employee were allowed to confer in a conference room during 15-minute hourly breaks, the agency was not required to allow additional conferences outside of the meeting room. Confidential communications between a union and an employee constitute protected activity. An agency may not interfere with the confidentiality of such communications unless it has been waived or the agency establishes an overriding need for the information. What remedies are available if an unfair labor practice is committed by the denial of representation? The posting and electronic distribution of a notice is a standard ULP remedy. But what about a remedy for an employee question in an examination where representation wasn't properly denied? First, if the employee was not disciplined, then the agency will likely be ordered to remove information from the unlawful examination from the employee's personnel record that could harm the employee and not use the information against the employee in the future. But what if the employee that was improperly examined is later disciplined? The statute's goal is to provide a fair process, not to prevent a just result. As a remedy, expect an order that the agency, first, remove any information from the employee's personnel record from the unlawful examination that could harm the employee. Second, repeat the examination with union representation. And third, reconsider the disciplinary action without relying on any information obtained during the unlawful examination. Then, if based on the new examination, the agency decides to rescind the discipline, the agency must make the employee whole. If, however, based on the new examination, the agency still takes disciplinary action against the employee, then the employee is entitled to statutory and grievance rights under law, regulation, or contract. So, the ULP remedy focuses on the process and attempts to correct errors in that process with a procedural review which could still result in a disciplinary action. If newly proposed action is imposed, other appeals may exist to review the matter. In this video, we explain the agency's obligations following a representation request and the rights a union has during an examination. Video 1 gives an overview of the statutory right to representation under Section 7114A2B. Video 2 discusses who is an agency representative. Video 3 focuses on bargaining unit employees. Video 4 covers what constitutes an examination. Video 5 discusses an employee's belief that they will be disciplined and if that belief is reasonable. Video 6 details the way an employee may request representation. Thanks for watching this video from the FLRA. For more information, please visit us online or contact your nearest regional office. A survey link is in the box below. We'd appreciate your feedback.